He'd win Holy, too.
Yeah.
We're going to go ahead and get started. First, I want to welcome everyone this morning, and to our alums in particular, I want to say welcome home. Thank you for being here. We're going to spend the next hour exploring an extremely timely topic. It's been on our minds here for months, and in the last week, it's gotten even more attention, both at Duke and nationally again. We're going to be talking about ethics and the law, lessons learned from the Duke Lacrosse case. I'm Professor Kathy Bradley, and I teach legal ethics here at Duke. I'll be moderating the discussion today, and we're going to be led by four very distinguished panelists, and I'm going to introduce them to you now. One of our panelists is Tom Metzloff, who's out breaking ground for our new edition because Tom has a very significant role in that, and so he'll be joining us as soon as he can. Tom teaches legal ethics and civil procedure here at Duke, and he's going to end our panel today by talking about the ethics rules that are at issue in the charges that are now pending against Mike Nifong, and he's going to try and explain for us the procedure that the North Carolina Bar Disciplinary Commission is going to be following as it deals with those charges. He's been quoted a number of times in the media in recent months about the ethics proceedings. Professor Jim Coleman, who's going to lead us off this morning, teaches criminal law and cases relating to wrongful conviction here at Duke Law. He's going to focus, I think, on the effect of the media attention and the prosecutor's conduct on the administration of justice in the Lacrosse case, both as it relates to the individuals who had been indicted and to the broader community of Duke University and to Durham. He's been singled out for particular commendation this week by a number of individuals for his tenacious insistence on adhering to the rule of law and the presumption of innocence with respect to the criminal proceedings that have been at issue. Seyward Darby is joining us. She's soon to become an alum of Duke University. She's a Benjamin Duke Scholar, and she will graduate next month with a major in English, a minor in political science, and a certificate in policy, journalism, and mass media studies. And I have a suspicion that the last year's events concerning the Lacrosse case have given her more of an education in some of these areas than she had bargained on. In addition, she is the editorial page editor of the Duke Chronicle, which is Duke's independent daily newspaper, and she recently won an honorable mention in the Melcher Family Award for Excellence in Journalism for her coverage of Duke doctors in Mississippi during the aftermath of Hurricane Katrina. In her spare time, if she actually has any, she's been heavily involved in tutoring students both in Durham and in Thailand. So she's everything we want our Duke students to be. She's in a particularly good position to offer to us insights on the Lacrosse case, both as a member of the Duke student body and as a journalist. And then we have Professor Mike Tigar, who is visiting professor at Duke Law this year. He currently is research professor of law at Washington College of Law at American University. He's renowned as an advocate and as an activist, and he's represented a number of clients in very high-profile cases, including attorney Lynn Stewart, Terry Lynn Nichols, and the Chicago Seven. So he knows a lot about what it's like to deal with the press in high-profile cases and with the obligations of attorneys in those cases. He also served as counsel to Dominic Gentile, the petitioner in the U.S. Supreme Court case of Gentile versus State Bar of Nevada, which he's going to be talking about today and which concerns defense counsel's First Amendment rights to speak to the press about a case. I want to thank all of you for being here today. We're going to give each panelist about 8 to 10 minutes to talk, and hopefully we'll have some time for questions. Professor Coleman?
Good morning. I came in expecting I was going to go second, so I didn't. Now I've got to sort of figure out how to for this to make sense without Tom sort of setting the context for the discussion. This was a case, sort of a wrongful conviction reality case. It was sort of played out in real time. One of the things that we learn in wrongful convictions, looking at cases of people who were innocent who were convicted, is that how important it is what the tone that's set at the very beginning of the case for the police and for the prosecutors. Usually what happens in the beginning dictates what happens in the end. And if the police and the prosecutors set out with a single focus, that dictates what happens. And I think in this case, it appeared to me that that's what the prosecutor was doing, that he had decided that a rape had occurred. He decided that Duke students had committed it. He decided that it was racially motivated, and basically he took over control of the investigation and then proceeded to try to find evidence to support his conclusions. And my concern was that given how the system actually works, that he would have succeeded. And it was only as the result of two really extraordinary things that he did not, at least that he did not get to trial. And I think that probably became his goal at some point during his investigation. The first thing was that the bar filed charges against him for his conduct and filed the charges in the middle of the case. That's really extraordinary. And then the second thing was that the Attorney General took over the case and then exonerated the students. You couldn't have written a script where that would have been the conclusion. I think at most you would have hoped that they had gone to trial and would have been acquitted, but I think it would have forever left open the question whether they in fact were innocent. I think that the way it played out removed any question about that. I think the Attorney General's extraordinary action this week, for most people, I think, settled the question that the students were innocent and that it's unlikely that any crime occurred. My concern in speaking out about this case, though, was not just Duke students. I mean, it didn't matter to me that they were Duke students. I would have been just as concerned if they were North Carolina Central students or UNC students, or if they were not students at all. My concern was that the manner in which the prosecutor was conducting the case made it very likely that innocent people might be charged with a crime that they did not commit, and as it turned out, that did not occur. The other thing about this case was that it was an opportunity to get the public to focus on how the criminal justice system works when there is a miscarriage of justice. This was not a unique case in the sense of how the system worked. That is how the system worked during Nifong's part of it. What was unique about it was who the defendants were, the fact that they had influence, the fact that they could afford the best lawyers in North Carolina, and the fact that the press was paying attention and reporting what Nifong was doing. In most cases, none of that's true. The defendants are poor, they often are people of color, they don't have good lawyers, and the press isn't paying attention. And so even in this case, with all of the things that the students had going for them, they were still indicted in a case where the Attorney General concluded that there was no probable cause. So, I think it was important for people to focus on that and to draw some, broader lessons beyond just, that these were Duke students who were being treated unfairly. Let me just say one other thing about, because, one thing about the university. There's been a lot of criticism of the university because people say it didn't actively support these students. It didn't, take on Nifong. It didn't, call for these students to be exonerated and so forth. I think that would have been a mistake. In fact, I think that it would have harmed their cause. It would not have helped it. It would have made it more difficult for the state bar to take the unprecedented step that it did, because it would have looked like they were yielding to pressure from Duke. It would have made it difficult for the Attorney General to exonerate them. That's a very unprecedented thing, because it would have made it look like he was yielding to Duke. And it would have played into the politics, Nifong's politics in this case, which was to make it a case about race, in which privileged white kids were basically running roughshod over the black community. and that he was the person sort of defending the community from all of these rich people and from Duke University. I think that the fact that Duke was not visible in the case, that the students were out there by themselves, that their parents were not conducting a campaign. In the very beginning, you may remember that there was an announcement that the parents had retained Bob Bennett to represent them, and I thought that that was absolutely the worst thing that they could do. Because, not because he's a great lawyer, but because that would have made Nifong's point that you bring in some high-profile Washington lawyer, and that's going to affect the outcome of the case, so that the students were basically left there by themselves with their lawyers to rely on the legal system. And I think that politically that made it possible for the bar to do what it did, and then I think it made it possible for Cooper to not just say that there was insufficient evidence to go forward, but to say that the students were innocent and that there was no credible evidence that a crime had even occurred. And then finally, let me just say that I think one of the bright spots in all of this was the statement of Reed Seligman when this was all over. He talked about the awareness that he had gained from going through this, that there are many other people who go through this daily, and we don't pay attention to it. And I think that if that message is learned, then I think that there really will have been something useful that came out of all this mess.
Thank you, Jim. Professor Tom Metzloff has joined us now that he's broken ground for our new wing, and we're going to let him go ahead and go next. And I think Jim did a good job filling in for the first slot, and I think Tom's now going to put this in context for us.
Well, the idea that Jim Coleman's filling in for me, it'd be the other way around. So I think there's been so many people talking about the heroes and victims, and if you didn't hear the press conference the other day by the lawyers when they talked about heroes, Jim Coleman was the first one mentioned, and I know I'm honored to be his colleague. Thank you. I teach ethics, so I have been interested in this proceeding ethically, and I wanted to just talk about what's left. It's now the Nifong ethics case, and I in a sense kind of want to assess with you how to think about that or how I'm thinking about that. It's a moving target, but there was a hearing just yesterday that we listened to, and I learned a little bit about it. But let me just sort of do it in the form of 10 questions. Keep me organized. I normally do PowerPoint, but don't want to bother with that today. It's better to just talk. What is this thing that's an ethics complaint? Most of us as lawyers are used to civil trials and criminal trials, and it's neither of that. It's neither fish nor fowl. It is not a civil case. There's no dollars that the State Bar is going to assess against Mike Nifong. It's not a criminal case. There are no jail terms associated with this. What's at risk is his law license. And to some, that's not enough, but for anyone who's a lawyer, we understand how significant that is. This is his ability, this is his job, this is his livelihood, this is his profession. And I think, what does the State Bar have to do? They are the plaintiff, they are the prosecutor, if you will. The rules do talk about conviction in some ways. So in some ways it has elements of a criminal case. It is a trial. It's not a jury trial, but they are making findings of fact and conclusions of law. If there is a result that either side wants to appeal, they get right back into the North Carolina Court of Appeals system and ultimately the North Carolina Supreme Court as if it were a case in the regular courthouse in downtown Durham. The State Bar's got to prove their case by clear, convincing, and cogent evidence. And all of you from law school remember, we seem to love this alliteration. We throw a couple of more adjectives in and hope it defines something, and it doesn't. But we know that's somewhere in between, beyond a reasonable doubt, and preponderance of the evidence, which is the normal rule for like an automobile accident. So it's more than just a little bit more evidence. They have to be clear, and the cogent one is the one that gets me. Normally it's clear and convincing. So what's the essence of the charges? What is the State Bar really alleged against Mr. Nifong? And there's two very different elements of it, and I think there may come to be a third, and I'll be interested in what others think. It began in December when they filed their initial complaint, and it's here. It's the first half, roughly, of what you have. And it related to his pretrial comments made in March after the incident over on Buchanan Street and when he took over the case. A series of a couple of weeks where he was on, gave many, many talks. And an extraordinary amount, maybe some of you saw some of them. I've been trying to collect some clips, and I have only a few, and it's not worth showing them. You've read about them. You've probably seen them. And that was the heart of the charges, that those violated ethics rules 3.6 and 3.8. And we'll talk specifically about them. But in January, the State Bar amended their complaint. That filing in December precipitated Mr. Nifong recusing himself. That's probably when I first began talking about the case, saying that the filing of that I thought was a clear conflict of interest, as did almost everyone, not quite everyone. And about 2 weeks later, he sent the case to the special prosecutor that led to Attorney General Cooper's statement this week. But in January, amidst all the evidence about the DNA reports and whether the submissions that he gave to the defendants during the course of the last fall, whether that was complete, that became the second major element of the case. The complaint was basically doubled in length, and a new set of accusations, very different, and in some ways, I think, to the lay people, sort of more clear, more wrong in many ways, was the failure, the candor of tribunal to the court. He did not provide the information, did not say what he should have said to the court when the court was asking about disclosures, and did not provide to the defendants and their attorneys information about DNA. So that's the second aspect of it. Now, you sort of say, which one of those is more serious? And I think that's an interesting question. I do think the failure to turn over information is more easily understood as something that shouldn't be done by any lawyer, and certainly not by a prosecutor. It's a little bit more complicated in that information about the report was given. There is a report that basically says that the three defendants, there's no DNA material from the three defendants in the samples that were tested. There is also literally almost 2,000 pages of scientific data and reports from the DNA firm, from which someone who knew what they were doing could pull, I was going to say divine, but it's more than divine. You could pull out additional information. But the report itself did not go further to say that DNA material was found from other non-defendants. And the heart of the allegation was that that is exculpatory evidence. That's information that should be turned over. I personally think that the comments themselves are also very serious charges. If you go back to understand what really went wrong in that case, something that's still a moving target, it is the incredible public comments by the district attorney, the person that in many respects we all rely on for some signals about what happened. Now, I think there are good questions to ask about how everyone reacted to that information, but this is what was being told to the community, to the leadership of Durham, to the leadership of Duke, to the leadership of North Carolina Central and elsewhere as to what had happened. So, what did he say? I want to talk about the publicity thing, and I was asked by many reporters, well, what's the worst thing that he said of all these comments? And I said, my response was, that's a good question, and I'm more used to asking the questions than answering them. Talk to somebody else. But, in some ways, if you look at Rule 3.6, which is in your materials, it's some parts of it are cut and dry. The first thing that you have to prove if you're the state, and I'm going to try to prove your state somewhere in the middle, I don't know if the pages are numbered. You have to prove that the lawyer made an extrajudicial statement that he knew would be disseminated by means of public communication. Okay, lawyer says something that you think is going to be published. Easy. He's talking to reporters. He's talking to TV cameras. No problem there. Not going to be a point of big defense. That could come up sometimes. There are some times that off the record a prosecutor might be talking to someone and it ends up in the paper and he didn't mean it to be. So that's not the case. So that's not that. So what does then the State Bar have to prove? Question 4. I'm going to come back to what's the worst thing he said. I'm going to answer that later. They have to prove that Nifong knew or reasonably should have known, and that's important, because knew or reasonably should have known does not mean Nifong intended it. It's an objective standard. It's what, you can get lawyers or the panel to think about what would a lawyer have thought, a regular attorney, and it's an objective standard. That the comments would have had a substantial likelihood of materially prejudicing an adjudicative proceeding. Substantial likelihood. We've been talking about that in my ethics class. How do you prove that? What does that really mean? And it's, at some level, maybe the simplest thing is, well, can you get a jury pool? How hard is it going to get to a jury? And the defendants filed a motion for change of venue. It didn't get acted on. It will not get acted on. So in some sense, we have to speculate. But for my own take, I think a change of venue motion would have been about the easiest motion of imaginable for those sorts of things. I offer myself as evidence. I live next to Michael Peterson. For those of you who followed the Michael Peterson murder case on Lifestyle Station tomorrow at 8 o'clock is a dramatization of it. I don't know why it needs dramatization. The real thing was fascinating enough. But that case captivated Durham in some of the same ways as this case did, not nationally, but certainly in Durham it was headline news. Even though I knew Michael Peterson, I was his neighbor, I didn't know him that well, I could have been on that jury. I would have done my best. I would have tried. I don't think I would have been picked. I couldn't have been on this case. I was too upset by what had been said. I was too upset about what had been said about Duke, and too upset about the way he handled the case for the reasons that I'm sure Jim Coleman described. And I know very few people among the people I know in Durham who could have been on that case. I think it would have been extraordinarily difficult to get a fair jury. And not so much for the conventional wisdom, well, there might be some African Americans who would vote to convict. I don't believe that that would have been a significant problem. I think the problem would have been people associated with Duke who were so upset about the kind of allegations that had been made about the university and the ongoing investigation and the way it had been conducted. So I think the State Bar should be able to prove by clear, cogent, and convincing evidence that there was a substantial likelihood of materially prejudicing adjudicative proceeding. It's not certainty, but a substantial likelihood. Well, back to the comment. Which one was the worst? Well, if you read Rule 3.6, it provides a laundry list of what you can say. So in many respects, it provides some information about what you can say. And it's a lot like Joe Friday and Dragnet, just the facts. You can say what you're doing. But it doesn't say very much about what you can't say. In some ways, you need to go to Rule 3.8 there. And Rule 3.8 is the rule for the prosecutor, special ethical rules for the prosecutor. And for some of you who think that maybe this ethics code is like the tax code, maybe some of you have been dealing with that this week. I finally gave up. I finally decided I will never understand whatever the alternative minimum tax is, and I'm sending all my stuff to someone else, and it's too bad because I used to like doing my taxes. Is this like the tax code? Is it incomprehensible? Does it have nuance? And the answer is no. There are 56, I believe, or less than 60 rules in the whole ethics rules of the North Carolina Bar, same as the American Bar Association. You can look through the table of contents, and I've actually done this with non-lawyers, and say, okay, you are a prosecutor and you're worried about what you can say or not say in an investigation, go. And it takes about 2 minutes to find 3.6 and 3.8. The title, if you look at it, is prosecutor. And you go down. So it's easy to find the rule, and it's not a long rule, and this should be known and easily known. So what does 3.8 say? It says something that's important. You have to refrain from making comments that serve to heighten public condemnation of the accused. And I think this is going to be very important in this case, because that's in the essence of what's going on. You can't help but watch the 60 Minutes that Jim Coleman was on and talking to the parents who talk about death threats. You can't have been at Duke and understand the pressure on the lacrosse players. Many of them, if not all of them, moved out of the houses that they were in, and the media coverage and the like. Heighten public condemnation of the accused. And it seems that that's a good rule. We need to avoid vigilante injustice. That's important historically, and it's as important today as it has ever been. And that's the heart of what went wrong. So what's the worst thing? Calling them hooligans? There was one thing he said that was on SportsCenter, and none of these public statements are really, they're not denied in his answer. I think we have part of his answer in here, but he did not deny them. He sort of said, I said that, or I said something like that, with one exception. And this is very important if you're a Duke Law School person. The State Bar alleged that Nifong talked to a reporter from that famous piece of journalism, the devil's advocate, and said something that was like this. And I read, and one of my students said, who's on the devil's advocate, said, look at this article. It's pretty clear that this guy didn't talk to Nifong. So I called up Will Smoke, who graduated a couple years ago, said, did you talk to Mr. Nifong about this? He said, no. I just sort of heard that somewhere said that. And I said, okay. So I emailed the State Bar and said, if you ever amend your complaint, this one is, and sure enough, that's the one he denies. I did not talk to anybody from Duke Law School. So. Okay. So he did say this: if they were innocent, why did they hire lawyers? Now, what do you do with that? When I was talking to the News and Observer, who've done a very good job with this, if you haven't got the News Observer today, please get it. Joe Neff is starting a 5-part article, and this morning is unbelievably interesting and important in understanding this case. Joe Neff was on a panel that we did earlier and has been working very hard. I think he's a very careful reporter. Not that he doesn't, like all of us, make some mistakes from time to time, but if you please do go to the newsobserver.com and read today's first piece. It's about the origins of the comments, and I'll let you draw your own conclusions about the motivations. But, I was quoted saying this, and I kind of like the quote, but I'm not sure I'm right. I said, some of his things just were, and he said, my reaction to that was, that's just dumb. And some of my friends have been using that back to me from time to time. But other people have said, no, it's not, it's much more than that. That's a profound misunderstanding of the way the legal system should work. I don't know if it's unethical or not. I'll let others leave that. But that's the kind of comment. The hooligans comment is the only one that he publicly apologized, and I'm using the apology term in the normal sense of the word, rather than whatever we want to interpret happened on Thursday. But he did apologize for that. He said from the beginning, I shouldn't have said that. Because the rules in the comments, if you read the comments, talk about you're not supposed to do things that say people are guilty. You're not supposed to do things that bring sort of this sort of condemnation on people. So that is a word. I guess that one never bothered me as much as the other things. What bothers me is the statements about guilt. Now, what are his defenses going to be? His main defense in his answer is, I didn't do anything intentionally wrong. I didn't mean it. And I think that's important when you get to the sanction phase. I think that will be relevant. It doesn't seem, as I read these rules, to be directly relevant to the defense. They are not criminal mens rea type offenses. They are new or should have known. And so the intentional defense, I think, does not work to have any significant impact at the beginning. Now, he did file a motion to dismiss, and the motion to dismiss related to the DNA evidence. And he said, they got the stuff. They got it before the trial, so I could not have constitutionally denied them a fair trial. And there's a certain, kind of remember like your math proofs in 8th grade, QED, that sort of says, okay, well, let's think about that a little bit. And the State Bar has responded well on that. They said, well, that means that any time somebody does a plea bargain and you didn't turn the evidence over, it's not unethical. I mean, for a civil litigator, that never made any sense to me, because if you don't turn over the discovery you're supposed to, the fact that you might sneak it in, the day before trial, I don't think the judge is going to care and think, oh, well, I'm glad you finally turned it in. You turn your homework in finally. So the State Bar yesterday denied that motion, and basically, I think, reading between the lines of the comments, said, no, that's not a defense to that. The criminal defense lawyers have also said, well, we still haven't had a full disclosure. We don't have a report that fully interprets those 1,900 pages of documents. The most interesting question, I think, and I certainly remember talking about this with my class from the very beginning of it, is Rule 3.8 says you cannot heighten public condemnation of the accused, if you look at that rule, of the accused. Virtually all the comments were made prior to the arrest of the first two defendants, and all were made prior to arrest of the third defendant, Mr. Evans. And he raised in his defense, and I'm not surprised, and I've talked about this before, the accused. There was no accused. And it's interesting. And so what's the argument there? Is the counter-argument that the accused was the entire lacrosse team? And I think one can make a good argument, and certainly my students who have debated this, that he really did accuse the entire lacrosse team. They all had to give DNA samples with one exception, and therefore they were all sort of under the microscope. But it is hard to think of 46 accuseds under that rule. So, we do have to kind of do some legal interpretation of that term. Now, the other thing he's going to say is the rule permits statements outside that litany of what's permitted, which he certainly went beyond, for prosecutors for legitimate law enforcement purposes. And that's one of those legal things, the exceptions that prove that, does that sort of the exception that sort of swallows the rule? Is that so broad a term that he can say this was all legitimate law enforcement purposes? Well, we don't know a whole lot about it. There's not a lot of law about this. We haven't had lots of prosecutions of prosecutors under this rule. I can't cite you 18 cases that have interpreted that term. But what seems to be implied by that are statements that deal with what? Asking questions to try to, making statements to get people to comment, to get people to come forward with evidence. And you can take some of his statements as strong requests to come forward. And that, I think, might be a legitimate law enforcement purpose. I need to move ahead, and maybe we should say more. What's the impact of Attorney General Cooper's statement on the case? That has not yet been, we're still sort of going through that. But what I heard the other day was very strong. It was innocent, and that there was not a case. And that's not a brilliant interpretation. That's what he said literally. The most core part of this case is whether there was a case now. And we'll learn something when Attorney General Cooper files his facts this week. But if you look at Rule 3.8A, the number one thing that Rule 3.8 is about, what does it say? The prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. I think the State Bar's got to look at that and think whether it's time to amend the complaint and say he violated that rule too. I don't see how you can look at what Attorney General Cooper said without raising that question. Now, note there, it's knows. It's not knows or reasonably should have known. This is much more that. Now, we define know. The terms say, denotes actual knowledge of the fact in question. A person's knowledge may be inferred from the circumstances. So in some ways, Jim Coleman would be the expert I would ask as to whether that standard was breached. But that's the heart of this case. To some respects, these other issues are secondary. The questions about the statements, the DNA. Really the heart of what we've all been worried about, and now what we've been really agonizing over the last couple of days, is that fact. Did he have any basis for a case that was supported by probable cause? Not just at the beginning, but as it continues. It's prosecuting a case. It's not initially filing, it's prosecuting. What sanctions are available? Gets interesting. We don't have a database of disciplinary actions. I can't tell you that 9 out of 10 times someone who does these kind of comments gets a suspension or a reprimand. The range is from a reprimand, which non-lawyers say is a slap on the wrist. Lawyers understand that to be something more than a slap on the wrist, at least most of them, to a suspension, to disbarment. Disbarment's very serious. There's no guarantee that you will be reinstated. Suspensions are what they sound like. Any of those latter two should have significant impacts, although no one seems to know that if a prosecutor is suspended, do they have to quit? You are a district attorney. Your job is to represent people in court, but there is no certainty of that. So how do you assess sanctions? Well, it's a laundry list, just like you'd expect, of aggravating and mitigating circumstances. The aggravating circumstances, I think the most important one would be selfish motive. If there's a selfish motive, they'll go harder on you. People say, well, this wasn't about money. If you read Joe Ness' article today, you can make an argument. It's about pension. He's planning to retire in 2010. His pension basically doubles if he's district attorney for 4 years. There's also the selfish motive of being reelected, and I think that's what the issue is. How do you prove that he did this to get publicity for election? That can be proved. The campaign director for him, who is no longer his campaign director, has quotes in the statement. If she testifies at the trial, I think you can prove selfish motive. His basic argument for the defense will be, I was a political novice. I did not know what I was doing. I've never done this before. I was an inexperienced politician. And you hear a lot of people say that, and there's certainly something to it. I wouldn't know how to play the media when they're knocking on my door in such an extraordinary case. This was a whirlwind. I rode the tide. It's a long tide, but he rode it. The State Bar, I don't think will go for that. Their view is these rules are clear, these rules are there, and you are a 29-year experienced prosecutor. And so there are two very different images that will be important there. What sanctions should be given? When asked earlier, I suspect this case can be made, and that certainly something more than a reprimand is in order. and that it should be a suspension. I think if we actually get to the other violation of 3.8 and they proceed down that path, they may think they have enough without proceeding there. You could even think more seriously about that. I think I will stop there, and maybe we'll have a chance during questioning to bring up some of the other points. But I appreciate the opportunity to be here.
Thank you, Tom. I want to add one thing to one of the things that Nifong said was that about why he dealt with things the way he did is because they never taught him in law school how to deal with the press. And so we've stressed to our students that we never want to hear them say that. Seyward, we'll hear from you next. Thanks.
Sure. Well, I'm a bit humbled to be here. I'm not a legal expert. I don't even have a degree yet. I'm an English major, so I know a lot about poetry. And I'm a journalist, so I know a lot about on the record, off the record. So if you have questions about that, I can go there, but very little about clear, convincing, and cogent. But I'm just going to briefly discuss a bit of the media context of the case and then discuss how, with relation to Nifong's ethics, the media failed. And this is as a member of the media, so a bit self-reflective here. So when this case first broke, it actually was on a really kind of fascinating day for us as the student paper. It was the same day that the men's basketball team fell out of the Sweet 16. And if you worked at the Chronicle while you were at Duke, or you ever have, you know that after that, news kind of stops. There's just not much else for the rest of the year. And I vividly remember having a conversation with my sports editor about how we were just going to be coasting. And not so much, basically, because soon after the DNA testing happened and it exploded. And it was fascinating to us because it was certainly a huge deal for our campus, and it was a huge deal for the student body. Here you had 46 of your own being taken down to be DNA tested. But what was really shocking was when the New York Times showed up, and when the Abrams report showed up, and when basically every network and every major news source in the country was suddenly knocking at our door, using us as kind of an intermediary to try to get the facts that they had missed in the initial days, because they didn't show up immediately. They took a couple of days to get down here. And I think that looking back on it, as a student paper, we were in an interesting position, and it's very different than other papers. We only run 5 days a week, and so when news happens over the weekend, which if you look back at the pattern of this entire case, a lot of news happened on the weekends. It's the traditional Friday news dump. They just kind of throw it at you, which made it really easy for us because we didn't have to publish anything the next day, and so we could just work on it all weekend. But when it came to news networks that publish immediately or online or daily papers around the country, they were dealing with an instantaneous nature that we were not in the same way. But looking back on it, and I'm in a media ethics class right now, and as a result, I've been doing a lot of reading of national news articles from last spring, and Nifong's comments come up again and again and again. The hooligans one, I think, is probably at this point the most famous comment he made, just because it's so severe, the accusation of hooligans. But I agree that the most troubling to me are the ones related to guilt and innocence. And there are two particular venues when he made those comments. One was that he was standing outside the Durham County Courthouse, I believe, and the other one was at North Carolina Central University. There was a conference of sorts there, a press conference of sorts, and he made some really vehement statements about how he was absolutely convinced of the guilt of whomever. Again, at this point, there were no directly accused. This was before the initial two were arrested. So then to take those comments and to look at them in the way the media presented them. What's the most troubling to me when I look at articles and broadcasts is the lack of contextualization. So, for instance, he would give a statement, and it would be published, and then you would expect in that next paragraph to point out that there is no evidence pointing to guilt, that no charges of any sort have been filed, a way to temper these statements. And that was often lacking. Especially in TV, because what they would do is they're live, right, standing outside, they're videotaping him, and as soon as they're done, they say, okay, that was a live press conference, and then they frequently moved on to other news. At that point, they didn't have quite as many talking heads as they managed to gather in the next couple of weeks, and so there was nobody to be critical of those statements. And I think that that's really where the media failed. The media are not lawyers. They are not legal experts per se, but they do have a responsibility to contextualize and to question statements like that are being made directly to them. And I think that the media did not do that as well as they should have. Some did it better than others, and some did it much more horribly than others. I think that there are three reasons that this came about through the media. And I think that first is just an unfortunate trust in public officials, which is something that you wish you could have. And when someone of the authority in the position of Nifong is making such comments, there's kind of the tendency to think, well, surely he must know something. My mother is actually good friends with his wife, which has made for a really fun year for us. And I remember we had daily phone calls, and she would say, he must have something up his sleeve. He would not say those things to the press. And I said, Mom, I just don't think he does, And we still kind of argue a little bit. But I mean, I think that what my mom, I love my mom, but what my mom was saying is kind of similar to, I think, what the media was writing on was, if he's making the statements, there must be something, and so why is there need to be critical? So it was kind of this unfortunate trust. I think the second thing that the media was playing into is just a sense of competition. And anybody who's ever worked in the media, especially nowadays, as things become more and more instantaneous, more and more up to the minute, there is this need to publish whatever you can as fast as you can, especially with the advent of online. And that means that whereas at a newspaper, for instance, I read every article I did when I was the editor last year. I read every article that went into our paper. And there was somebody before me, usually two people before me, who had read that. But when you're talking about online or when you're talking about TV news that's live, you don't have the set of editors, looking over your shoulder and saying, well, I think you should actually question that a little bit more. It's just there. It is there for the public to see. And that's because of this need to be competitive with each other. And I think that was a pretty huge failing. And then I think also it was just people want provocative content. And I think these very vehement statements were certainly provocative. And to look at other statements that were made, it was really troubling as a student when you walked around campus, and for the most part, students really had no idea what was going on. We were all sitting back and watching and wondering just as much as anyone else. There were certainly those who presumed they were innocent. There were certainly those who presumed they were guilty. But for the most part, the large block of us were just saying, oh my Lord, what is going on? And then the media would come in and they would interview people. Again, this kind of goes to TV news especially. And they would pull out the extremes. And those were the statements of Duke students that were being put out there. It was the most provocative content. And so that kind of plays into the same thing. And so I think that those three things are really what was kind of driving the media. And I'm not trying to speak for networks or newspapers, but this is just, having reflected back on it, where the major failings seem to lie. So I think now, it's really funny to actually read the most recent coverage. For instance, if you have read any articles recently, they are so careful to say that Roy Cooper is running for re-election. Every single time. He is a Democrat running for re-election. And that was one of those things with Nifong where it definitely showed up, but not as often as you would expect, that he was running for re-election. And I think that the media has become a lot more tempered in their dealings with this because they saw the effects that their errors had last spring. So I'll be happy to answer any questions you might have, whether it be about our coverage or other coverage. Again, I can't speak to everything. I haven't read every article or seen every broadcast, although I've seen a lot. I'm not a legal expert, but I am a lacrosse expert. It's really quite amazing how often my conversation somehow turned to lacrosse. So I thank you for having me, and I'll let the legal experts take back over.
Thank you, Seyward. Professor Tigar.
In your materials is a summary of the holding in Gentile versus the State Bar. There's an opinion by Judge Mage, which was based on expert testimony by Scott Armstrong in the Nichols-McVeigh case on the impact of media on potential jurors. I think that's worth looking at. There's also an opinion by the 10th Circuit on sealing orders as a way to control publicity, kind of as a preventive thing for lawyers to do. And an article by Emily Bazelon that notes how rare it is that prosecutors get disciplined for doing things that Mike Nifong is accused of doing. When I was preparing to argue the Gentile case, I couldn't find a single case reported, a court case affirming discipline against a prosecutor for a press conference. Now, I come at this with some experience. I was a member of the defense team for Kay Bailey Hutchison. who is the only member of the United States Senate with a piece of paper signed by 12 jurors saying she's not guilty. The other 99, you have to take their word for it. For Governor Connolly and for Ron Dellums, who you may recall was accused by Ed Meese of having dealt dope out of his chambers, a firestorm of publicity. I got in the case 2 hours after Meese had leaked this allegation. And I don't know if Peter remembers this, we had to meet the media. Well, what do you say? I stepped in front of the cameras and said, well, we deny the allegations and we're looking for the alligators. Now, what is the impact of what happened here? I think one of the most serious things is to have derided these potential witnesses. We hear this. Why, if they weren't guilty, why do they hire lawyers? Now, everybody here laughs. I was trying a case in New York City in which Ramsey Clark was going to be called as a defense witness, and the prosecutor said, well, Your Honor, I'm fixing to cross-examine him. You know, he has represented people accused of terrorism, and I want this jury to know that. And Judge Codal said, say what? Well, this is that the jurors could draw an adverse inference about him. And Judge Codal said, no, they couldn't. They might, but they shouldn't, and they won't, and you can't. But this is a United States attorney in the year, in the common era, 2005, who still holds on to this idea. One of the things the papers have brought out is that if you are a victim of sexual assault and you want to come forward, 42% of sexual assaults never get reported in the United States of America today. And if you think you're going to be in a firestorm of publicity, think of what that does to your reluctance to come forward. This is a major problem. It's a major problem on college campuses, particularly when coupled with alcohol usage. And I got to say that lacrosse team, if your summer associates had had a party like that, you would be looking into it. Just by the way, while we're looking at this, and the conduct of a district attorney who does this is bad for law enforcement. For me, the most significant thing about General Cooper's press conference on a going forward basis is that he says there has to be a mechanism to remove prosecutors who do this sort of behavior. Now, I have twice in my legal career succeeded in removing prosecutors from cases who do this sort of behavior. In one case by order of a judge. In another case, you may remember the Charleston Five, the longshoremen down in Charleston that I represented. And we moved to disqualify the Attorney General, who had done what will forever now be known as done a knife-on. The day we were to down there and have pretrial hearing, Judge Rawls had indicated that he just might grant the motion. The Attorney General withdrew. So judges have always had the power to sanction prosecutors under these circumstances. But the problem here is, and I'm very glad that we have someone from the media who's talking about this. Look at the media coverage all over America. They're pointing at knife-on, they're pointing at this, they're pointing at everybody except themselves, right? They never read Alexander Herzen's words, we're not the doctors, we're the disease. And unfortunately, it's a disease of which we cannot cure ourselves because we have this wonderful thing called the First Amendment. We have to rely, to the extent we can do anything about it, on our profession, on establishing and maintaining and seeing that these rules are respected. And that, to me, is the challenge. It's a challenge that the ethics teachers here at this great law school are taking up. It's a challenge that we as lawyers have to recognize when we get into these cases. Yes, it's tempting to have our own 15 minutes of fame when the reporters come, but that's not in our interest, our client's interest, or in the interest of the system that we're sworn to protect. And we've got to figure those things out. And we need to figure them out because, you know, Tulia, Texas, the drug bust there, this case, your colleague, a 66 graduate of this law school, Hal Haddon, in the midst of the Kobe Bryant case, and even, I want to leave you with this thought, you know, there's a guy accused now in Durham, it's called Mike Nifon, and he too is entitled to a fair trial, even when there's a risk of unfairness from a firestorm that he himself has created. And if we can all go forth and say that, you know, no matter how bad we just know somebody is, We can't be like Governor Keating was in the Nichols case. We will give Mr. Nichols a fair trial before we execute him. We have to get the bar raised just a little bit higher.
Thank you so much, Professor Tigar. Before we take a few questions, I'll ask if any of the panelists want to respond to anything any of their co-panelists have said. Okay? Do we have questions from the audience? Yes, sir.
Getting the ethics charges filed seemed to be the key in the case, and are we going to start seeing more of that as a tactic to try to change prosecution in cases?
Well, I don't know if it can be a tactic. I mean, how does the State Bar decide who to file? They have a grievance committee that meets quarterly. They met actually in October on the Nifong case about publicity, but sent a letter to Nifong to respond. And it's interesting, that was still during the general election, and he had an opposition. And one of the questions in the Durham papers have been, did he know that he was that the grievance committee had voted, had found probable cause to file against him, and didn't he have an obligation to tell that to the public in the voting? So how do they get that? I can't, or any individual lawyer in North Carolina can't file that. What you can do is send a letter to the State Bar, and they decide to investigate it. They do their own investigation. They can do it on their own. They do not need a letter, and they can just sort of, they have a staff of a couple lawyers and other members to do it. So I don't know if just sending a letter in will ever automatically trigger that. The State Bar is under a different kind of pressure here in North Carolina as well that impacts, I think, both the sanction issues as well as this decision. There's been several very high-profile cases, and I know Jim knows a lot about some of these other cases, against other prosecutors in death penalty cases who did not turn over exculpatory evidence. Those cases, in one case was proven, but only a reprimand was given. And the people who are who are arguing for a less serious sanction should, and Michael's right, there's a trial and there's facts to be found, are saying, how can you go after this guy for this compared to only a reprimand for those people? And that's always a difficult question, and every judge in this room knows those questions of sort of horizontal equity in cases. So I don't see this ever becoming a tactic. I do think the State Bar has decided to make sure that these provisions under Rule 3.8 are important, and I think we'll have a greater sensitivity to it, and that's a good thing, I think. Maybe
Move to disqualify. Move to disqualify. In the Charleston case, the day after Condon was forced to leave the case was on its way out the door.
Yes, sir.
What was the trial judge's responsibility, if anything, to intervene and correct this problem? And if the trial judge had a responsibility to do so, but did not, to what extent could Nifong claim that the court was in effect tacitly going along with what I was doing? And I'm talking about including the November hearing when the director of the DNA lab stated under oath in the presence of the court and a large crowd, including Nifong, that he and Nifong had conspired to withhold exculpatory evidence in violation of the United States Constitution.
It is a puzzle to many people as to the role of the state judge. It's a puzzle to the State Bar. At the first hearing about the case on the ethics complaint, the head of the panel said, has the judge in the case done anything about this? And if he were to do it, maybe we should hang on and let him do it first. The arguments are candor to the tribunal. You have a tribunal. You'd like to know, did that judge feel that his orders were specifically violated? How? Because that would be the best finder of fact. And nothing's happened. So we're all puzzled. I know a lot of federal judges who find that shocking.
The reason that nothing happened is because when something wrong happens and you're presiding over a case and you don't act as you're required to act under the law, and then it keeps repeating itself, you find yourself in a position where you can't do anything, because then everybody says, well, you should have done that at day one.
And so I think the judge has been content to let the State Bar take up the burden of this, as have others. Jim, you might want to.
Yes, sir.
I'd like to put a little different tact on this and ask a question of the panel as to what effect you think the national publicity in this case will have on the whole system of prosecutorial approach to criminal trials. Let's convict the person who's in front of us. Let's not worry about whether it's the right person or not the right person. The evidence is there sufficient for a conviction. I want to move forward, even though there may be other evidence that would indicate that somebody else may be guilty. And I'm really interested in what you think might happen with respect to prosecutorial misconduct, looking at the statistics cited in the Bazelon article of 381 state murder defendants released subsequently because of prosecutorial misconduct. Will the publicity in this case have any positive impact on holding prosecutors to account?
Jim, you take
I guess I'm kind of cynical about that. We hope that it has that effect, but I think this was a unique case. I think that if the bar had not got involved, that this case would have run its course in the way that, these cases often run their course. It would have gone to trial, a jury would have acquitted, NIFON would have said the system worked, and then moved on to the next case. But I think that that wasn't possible given the national attention here. And once the bar stepped in, and I think the whole thing fell apart. I mean, Tom mentioned Cooper in other cases. He defended a death sentence in a case where prosecutors withheld 17 statements by witnesses who said that the victim was alive when the state conceded the defendant could not have killed him. And he defended the death sentence in that case, and then retried the person who was quickly acquitted. So, we'll see. I mean, I hope that in the future, Cooper will take the approach in other cases where there's not the national spotlight that he took in this case, but I wouldn't bet on it.
Every case that changes our national attitudes is a unique case until it gets the kind of national publicity that this one gets and changes attitudes or focuses a spotlight on a systemic problem.
And then
My question is this one of those cases?
Well, that's the point. So the real question is it going to have an impact when the cameras are turned off? And I don't know, but we'll see.
We're out of time, unfortunately. I want to thank our panelists, and I want to add one thing. In terms of the future impact, we expect to hold a conference here in September on the 28th and the 29th that's going to look at the broader issues that have been raised by the Lacrosse case and focus on the long-term impact for prosecutors, for defense counsel, for the media. So you might mark on your calendar those dates and plan on coming back. I want to thank our panelists. I want to thank all of you for being here, and I hope you enjoy the rest of the weekend.